Next is an interesting presentation from Mrs. Kosalai Mathan. Is Miss Kosalai Mathan here?
Yes.
Yes, she's here. Oh, perfect. So Miss Kosalai Mathan is from the Department of Law, University of Jaffna, and she's going to speak on something interesting called thesavalamai. So thesavalamai, and it's called land ownership. So here we go, Mrs. Kosalai Mathan.
I'm first thanking the organizers for organizing a discussion and offering me an opportunity to take part in. So when we think of investing and attracting, can you hear me?
Yes, we can hear you.
Yeah. So when we think of investing and attracting foreign investment in northern part of Sri Lanka, we must understand the law governing property and inheritance of property, especially in the northern part of Sri Lanka. So when it comes to property and inheritance of property, the law applicable in the northern Sri Lanka, that means all 5 districts in the northern province, is thesavalamai. As per the recent judgments, the thesavalamai has a wider application. That means it has both personal and territorial character. What is meant by the personal law character of thesavalamai is this. It is applicable to all the inhabitants of northern province of Sri Lanka. For example, if a person who lives in Jaffna owns a property in Jaffna or any part of the northern province, the property is governed by the law of thesavalamai. At the same time, if a person of northern province, any area of northern province, and if he owns a property in any other part of the country, for example in Colombo, the property situated in Colombo also governed by the law of thesavalamai. And this is the personal character of thesavalamai. And thesavalamai also has a territorial character. Irrespective of the fact that who the owner is. Owner may be a Sinhalese, Muslim, Burgher or foreigner, anyone. But if a person owns a land in the northern province of Sri Lanka, the law of preemption and OT mortgage applies to that particular land. So it has a limited territorial character and a wider personal law character. So this must be understood by any foreign investor before he prepares to invest in the northern part of Sri Lanka. So now I am yet to explain the 3 main categories of properties under the law of thesavalamai. There are 3 main classifications of properties, especially immovable properties. First is mudusam. Second is chidanam, dowry. Third one is acquired property or third. Mudusam can be acquired by a woman or a man through his parents or ancestors. If a property is acquired in the name of mudusam by a man or a woman, it is called or it is recognized as the separate property of the person. But there is a discrimination under the law of thesavalamai with regard to separate property. If a man has a separate property in the name of mudusam, he has absolute right over that particular property. That means he can transfer or dispense with the property without the interference of anyone else. But the same right of freedom is not given to the women who are governed by thesavalamai. May that be a separate property of the woman, but she can't dispense or transfer the property without the written consent of her husband. The same provision is applicable for her dowry property as well. Dowry property is a property given to the bride at the time of marriage or prior to the marriage or subsequent to the marriage. The sole owner of the dowry property is the bride, the woman. But as per the Jaffna Matrimonial Rights and Inheritance Ordinance, the written consent of the husband is required by a woman to transfer her property, meaning to sell, mortgage, or any other transfer of the property, she needs to get the written consent of the husband. So this written consent from the husband is a unique and a discriminatory arrangement that we see under the law of thesavalamai. The women who are governed by the general law are given the femisole status, meaning that they have the freedom to deal with their properties. The femisole status or the freedom is not given to the women who are governed by the law of thesavalamai. So this is unfortunate, and because of this arrangement, a woman, if she needs to transfer, for example, to sell one of her separate property, may that be mudusam or dowry, she needs to get the consent that should be in written form from her husband. But there are some exceptional situations where this written consent from the husband is not required by law. Examples are if the marriage is dissolved, or if the husband is deceased, or if she wants to transfer the property by way of a last will, the husband's consent is not needed. In all other situations, the husband's consent is required, essentially required by the application of law. There are many women affected by this. For example, the wives of people of enforced disappearance. They are unaware of the whereabouts of their husbands. Because of this specific situation, they are not in a position to transfer their properties, even if there is any urgent situation to transfer the properties. But the Jaffna Matrimonial Rights and Inheritance Ordinance has a provision where the interference of the court is allowed when a woman needs the consent from the husband. According to Section 8 of the Jaffna Matrimonial Rights and Inheritance Ordinance, when a woman makes a complaint or appeals to the court saying that the husband is deliberately denying to give consent, or the husband is lunatic or idiot, or some other reasonable grounds are there, then the district court can grant the consent to the particular woman to deal with the properties. But when we practically see, this provision is not very frequently invoked by many of the women. The reasons may be lack of awareness, social fear, etc. So the investor need to be very, very careful about this legal impairment over the woman under the law of thesavalamai. Because a woman, even though she holds a property, she cannot transfer the property without her husband's written consent. There are a number of instances where properties have been transferred and sold without the consent of the husband. The legal consequence of this transfer is invalid. They are illegal transactions. Sometimes these kind of transactions happen out of ignorance. Sometimes there are fraudulent intentions to cheat the buyers. And when I move on to the aspect of 30th term, acquired property. What is acquired property is the property acquired by the spouses during the existence of the marriage, and they should have bought it for consideration. And all the profits they get from the separate properties also form part of 30th term. The special feature of 30th term or acquired property under the law of thesavalamai is the other spouse, we call it as non-acquiring spouse, automatically acquire the half share of the 30th term. If I give an example, if the husband buys a property out of his own money or out of his own savings, the half share of the property automatically goes to the wife. So 30th term is a co-owned property. Both the husband and wife are the co-owners of the property. The problem here is that the husband has no right to sell the half share of the wife without her consent. There are instances where husbands sell the whole property of 30th atom, including the half share of the wife without the wife's consent. This is a wrong practice, and the law prohibits this practice because the husband doesn't have dominion or control over the wife's property. So wife has control over her half share of 30th atom. At the same time, the husband has control and right, ownership over his half share of the 30th atom. But the problem is, again, the written consent concept applies here. Although the wife acquires half share of the 30th atom, soon after, though immediately after the purchase of the property, but she cannot independently sell her half share to anyone else. Again, she needs to get the written consent from her husband. But after the death of the husband or either spouse, the existing spouse is entitled to get another half share, half out of half of the deceased spouse. So at last, the spouse is entitled to 3/4 of the 30th atom property. So this is how the law of thesavalamai applies to the properties belonging to the people of Northern Province. And this thesavalamai applies to inheritance of properties too. So the mudusam, if the man has no children, it goes to ascendants, descendants, and collectors. The wife has no right over the husband's mudusam property. Like that, over the dowry property of the wife, the husband has no share. If the parties to the marriage have children, the children inherit the dowry property of their mother. And if there are no children, the property goes back to the ascendants, descendants, and collectors. So this is how the property matters are governed under thesavalamai law, and many people are not aware of this applicability of thesavalamai law and the impairments of the thesavalamai law. And if these provisions are not complied with, the transaction of the property becomes invalid and illegal. So in my point of view, it must be clearly understood, and the law of thesavalamai must be clearly understood by the investors to acquire the perfect ownership of the property they buy. Otherwise, there are a number of instances where these investors may be cheated or may be subject to legal consequences and illegal transfer of properties. And this is the basic idea of the thesavalamai law governing property, and I am very happy to answer if there are questions on this. Thank you.
Thank you, Ms. Kosalai Mathan. That was an excellent presentation. I was thinking life in Jaffna is simple, but it looks pretty complicated to me.
Can I ask a question, because my chat box is not working?
Yes.
Say supposing a person living in Colombo with Jaffna ancestry properties in Colombo, just assuming, does it apply, thesavalamai apply to them?
Thesavalamai applies to the person. The only thing the person has to prove is that his domicile is still in Jaffna or northern part. Maybe he has changed the domicile to Colombo, but he must prove that he has not abandoned the domicile, and at the same time he has to prove that he has the intention to return. So if that is true, even for a person who lives in Colombo or any other part of the country for a long time, there are chances for applying thesavalamai to that person and to his properties wherever they are situated.
Sorry, Uma, no escape for you.
No. I just want to find out. Want to find out how it works.
I have a question on the chat. What about the right of siblings who are living abroad but have properties in Colombo? Do you want to answer that quickly, Ms. Mathan?
I didn't get your question. What is it about?
What about the right of siblings who are living abroad but have properties in Colombo?
Whose property they have?
Good question. Is this Lasanta is asking? Lasanta, you can actually, I can unmute you. Mr. Mendes, it's a good question. Here we go. Lasantha, I'm going to unmute you. So you can ask, interact, Ms. Mendes. Okay, maybe we can save this question. Oh, here we go. He's on now. Mr. Mendes.
Yeah, my question is whether Sinhalese in Colombo can buy land in Jaffna.
Absolutely. There is no legal restriction burying a person from Sinhalese or any other part of the country to buy a land in Jaffna. There is no barrier, but there is only this barrier coming in the name of preemption. If a person has a co-ownership land, when he offers his land for sale for someone else, first he has to make the offer to the other co-owner. If the other co-owner is not willing to purchase the land or portion of the land, then the person has the absolute right to sell it to someone else, may that be Sinhalese, Muslim or anyone. So there is this misunderstanding that Sinhalese cannot purchase land in Jaffna. That is absolutely wrong. People can purchase land in Jaffna. Anyone can purchase land in Jaffna according to this application of thesavalamai, especially the preemption.
Okay, thank you very much. As you quite rightly say, this is a misconception, and thank you very much for clarifying it.
Thank you, Kosalai.